Heather Dryden, Chair of the Governmental Advisory Committee, thank you, first of all, for answering our questions.
Thank you. It's good to have this opportunity, I think, to talk a bit about the GAC and a bit about the communique.
Heather, let's jump right into it. Since the Beijing meeting, and even during the Beijing meeting, there was a lot said about the GAC communique and the GAC meeting there in Beijing. Why so much coming up in the community about both the communique and the meeting?
I think in part, and in hindsight, it's a result of us having those discussions in a closed format. In doing this, it meant that the community didn't have the benefit of seeing the exchanges among colleagues in the GAC, which were really very substantive and interesting. So now that we're seeing these questions arise, we're having to deal with them after the fact.
So what I'm hearing you say is, had these meetings been more open, these questions would have been answered at the time.
I think they would have, or at least better answered. The discussions that we had in the GAC around this were really interesting. They were substantial, and so it's unfortunate that the community was not able to see that at work.
You're the chair of the GAC. Why weren't the meetings open?
I think because of the sensitive nature of some of the discussions that some GAC members felt it would have been a bit too difficult to accomplish our work. And so we had made the decision to close those meetings.
Moving forward, will the GAC meetings be more open?
Yes.
Heather, have the GAC early warnings been a success?
Yes, they have. There have been a number of positive results thus far from the exchanges that resulted from issuing those early warnings. A number of the governments concerned and the applicants have taken advantage of that mechanism to resolve things, and in fact have managed to avoid even a discussion about some sort of GAC objection on those applications.
Differentiate for me between consensus advice and non-consensus objection advice.
Well, as you know, in the communique, there were two strings and applications where the GAC provided a consensus objection. And so what this means is that no GAC member formally objected to a consensus objection, and that was really the question that was put to the GAC. So, in other words, does any GAC member formally object to a GAC consensus objection on those applications? And that resulted, if there were no formal objections, in the GAC providing a consensus objection. There were other cases where the GAC provided some advice outlining concerns that a number of GAC members had, but where you did not have a consensus for that advice. And we think that is, of course, also very useful to communicate in relation to those strings and applications.
Heather, can you give me an overall characterization of that April 11th communique?
Sure. So the significant part of that advice, where I see there's a lot of interest in discussing, in particular, what it means for implementation, is with regard to the safeguard advice that we generated. And really the intent behind this was to provide a reminder or to reinforce the importance of pre-existing obligations and the applicability of national laws, and really not to impose new burdens on applicants or registrants. However, there are measures proposed in that safeguard advice where there are real implementation questions. And so we think this is a very good focus for discussions now in the community with the GAC and with the board around that particular aspect of the advice.
There was so much mentioned in that communique and so much that will promulgate further discussion. Does that actually translate to a delay in the delegation of new gTLDs?
I can't really comment on the timelines, since governments are really very satisfied with the results and the nature of the discussions that we undertook in order to generate that safeguard advice, that it needs to be given due consideration. And that there is a lot there that we have provided that has merit, and it really is appropriate considering the kinds of sensitivities that such an expansion in the gTLD space really represents.
The communique has been described by one journalist as a perplexing, frustrating mess of ideas that seems to have been hastily cobbled together from a governmental wish list of fixes for perceived problems with the internet. What's your reaction?
Well, I've outlined for you how governments view the advice that they've generated, and it's really not intended to impose a new global regulatory regime. It is intended to be consistent with ICANN's existing role and serve as a reminder to those that have applied of what is really involved with implementing, if they are successful, a string globally, as well as really wanting to emphasize that that some of those strings raise particular sensitivities for governments and should not be overlooked. And I think it's preferable to be coming up with safeguard measures in order to allow those to proceed, rather than having a discussion about whether there should be objections coming from the GAC or somewhere else.
The GAC said when gTLD strings represent generic terms, exclusive registry access should serve as a public interest goal. What does that mean?
It means that there should be good reason for having exclusive access, and it should be in the public interest. And it may be the case that the community has thoughts on the public interest and what that really means. So there may well be discussion about that particular point.
Heather, the communique listed a series of questions regarding public interest commitments, which demonstrated an obvious focus on PICs. Is that an area of particular concern for the GAC?
I think it is, in particular, the dispute resolution process that is part of the public interest commitment specifications. And that is what gave rise to the series of questions that the GAC generated in relation to that issue. It's an important aspect of governments wanting to understand how they could make use of those dispute resolution measures.
But there are critics who say the GAC wants to impose 11th hour rules on new G applications. What's your response to that criticism?
Well, there again are a few things, and I've touched upon some aspects of this already, but I might draw your attention to the discussion around categories that occurred very early in setting the rules for the program. And governments had thought at the time that this would be a good approach to address such a broad opening up of the space, to accommodate the different kinds that could be applied for. And because we did not have that, and we were given these processes we have now, which is early warning, and the GAC advice, then the GAC is simply taking advantage of those processes. We're making use of them, even if they're imperfect. And so this is really the GAC providing public policy advice, as it is mandated to do.
Your communique is now open. It's been posted for public comment. Kevin Murphy, who we all know of domaininsight.com, wrote that this could, in essence, be one of the most important consultations ever, since Kevin argues that it might well define the role of governments in an expanding domain name industry. Is that an overstatement?
Perhaps it's an overstatement, but that doesn't mean that this isn't an important process. I mentioned to you earlier that that for the Governmental Advisory Committee, this is really a significant package of advice that we have provided in our Beijing Communiqué. And we would want there to be due consideration given to its contents in light of that positive result from the perspective of the GAC.
How does the GAC balance the importance that you've already expressed and what the GAC feels are these very relevant, important issues that are laid out in the process, and addressing those with allowing the applicants to have a predictable time frame? How does the GAC balance those two concerns?
the GAC's primary role is to advise on the public policy aspects of coordinating the names and numbers for the internet. On gTLDs, we were given clear processes, early warnings, followed by GAC advice, and we outlined in the guidebook what that advice would look like. And we have acted upon that, and so that's the role of the GAC in terms of the organization as a whole and how different interests get balanced. The GAC is responsible for a piece of that.
Suppose the board in the end says, thank you very much for the advice, we've looked at it, but we're moving on, and basically ignores a lot of that advice.
I think there would be a very immediate reaction questioning the value of participating in the Governmental Advisory Committee. If it is going to be the place for governments to come and raise their concerns and influence the decision-making that occurs at ICANN, then we have to be able to demonstrate that the advice generated is fully taken into account or to the maximum extent appropriate taken in. And in this way, governments understand that the GAC is a useful mechanism for them.
At the least consideration, the GAC has to feel like it's being heard.
Yes. It has to feel like it, and it actually has to be heard.
What you seem to be saying is there's concern about whether or not some governments might pull out from that multi-stakeholder model.
Right, right. Why would they come? How would they justify coming to the GAC meetings? Why would they support this model if in fact there aren't channels available to them and appropriate to their role and perspective as a government?
Looking ahead to Durban, what is the GAC looking forward to at that meeting?
Well, we expect to discuss further potentially the 14 strings that we identified for further consideration. We will not formulate that agenda until closer to the Durban meetings. There may well also be aspects of safeguard advice that we would discuss further with the board or with the community or would need to, particularly the implementation aspects of some of the new safeguards that the GAC identified.
Heather Dryden, Chair of the Governmental Advisory Committee, thanks very much for taking the time to answer our questions.
Thank you very much.